Good morning and welcome to Dorsey and Whitney's annual training regarding municipal securities disclosures. I'd like to introduce David Grossklaus, a partner in Dorsey's public finance group. David?
Thank you, Rima. Welcome everybody to Dorsey and Whitney's 2021 annual training with respect to matters of municipal securities disclosure. Certainly nice to be taking part in this annual training again, and what a year it's been since we last provided annual training on these topics. So we'll hopefully this will be a good informative session for some folks, and main goal to try to brush up on a few items for folks from a training perspective. Few housekeeping matters. We're going to try to keep this discussion to 60 minutes roughly. The materials in the attendance form are available, as you see, hopefully on your screen, in the reminder email sent from events@dorsey.com. And you can return the completed attendance form to attendance@dorsey.com. We will try to have some questions and answers at the end of the session. If you do have questions, please email James Smith. You can see his email address there, smith.james@dorsey.com. I would also urge you, if you do have a question at a point in the presentation, please also feel free to send Mr. Smith an email, and we'll see if we can try to tackle it timely. Speaking to you today will be obviously myself, and then our colleague Jennifer Block. You can see our phone numbers there and email addresses, again, to the extent you have any follow-up questions. The agenda today, we're going to first just cover some real basic information. Then we're going to try to keep things a little topical, reviewing again some of the recent amendments to some of the rules that have been promulgated here in the last couple of years. We'll talk a little bit about the role of the SEC as it continues to evolve. And then Jennifer will walk through some of the policies and procedures. And then, as I said, we'll tackle some questions, and hopefully we'll have some answers. Let's jump in with the basics. We'll cover some terms, roles of counsel, and the regulatory framework. So first of all, glossary of terms, just again to ground everybody just a bit here. I will certainly be using shorthand, and so just by way of what I'm talking about when I use some terminology, let's start with the parties. The issuer, sometimes referred to as the borrower, depending a little bit on structure, but for points of this discussion today, when I say the issuer, that's going to be the governmental entity who's issuing the bonds and who's going to be receiving the bond proceeds. And just by way of reminder, it is the issuer for which the official statement is prepared. And again, just by way of reminder, the official statement is the document of the issuer who's issuing the securities / bonds and receiving the proceeds. An underwriter is the entity for which you folks have hired to go out and market the bonds to the public. They technically do purchase the bonds initially from the issuer. Then obviously they go out and market and or sell those bonds to bondholders immediately upon purchase or at closing. Municipal advisor, again, just to clarify a little bit, a municipal advisor provides financial advice. You'll sometimes hear more senior folks like myself refer to a municipal advisor as a financial advisor, and I'll try not to do that on this call, but the municipal advisor is the entity that advises issuers directly. And now municipal advisors are regulated, and the reason we refer to them as municipal advisors is because that's what new regulation labels them as opposed to financial advisor, but they are one and the same. The SEC obviously is the Securities and Exchange Commission, the federal government, I will sometimes refer to them as. The documents that I will use some shorthand for the official statement, and let me just also add, sometimes we'll say a preliminary official statement. So the POS is the preliminary official statement, the OS is the official statement. And just again, by way of background, the POS is the document that is initially distributed to bondholders. That is the document on which the bonds are priced. Once the bonds are priced, then we convert the POS into the OS simply by adding in the numbers, the prices, the rates, the principal amounts, and so on and so forth. Continuing disclosure certificate is the document or the contract, I would say, pursuant to which the issuer agrees to provide ongoing financial information to the marketplace. So the official statement is kind of the initial financial document, or what we would refer to as primary disclosure to the bond market. Once the bonds close, then you normally would all be executing continuing disclosure certificates or agreements or undertakings. And so that is what we would refer to as secondary disclosure. And that's the information which you're going to provide annual updates to the marketplaces, to your financial situation in an ongoing basis. Dissemination agent agreement, that would be an agreement that would normally be entered into as between the issuer and either a municipal advisor or some other entity, and that is the agreement by which the issuer provides information to the dissemination agent. The dissemination agent then ensures that that information is uploaded to the EMA website. I will just quickly reference, EMA is the Municipal Securities website hosted by the SEC that provides all the ongoing continuing disclosure or secondary reporting financial information to investors after the bonds have been sold. All right, moving on quickly. I won't delve too much into this. The differences very quickly between bond counsel and disclosure counsel, you can take a look at that. But the easiest way maybe for folks to think of the difference between bond counsel and disclosure counsel is bond counsel is tax and state law and regulation compliance. Disclosure counsel is securities and exchange compliance. So just as a reminder, you really have three sets of rules when you as issuers go off and enter the marketplace. You have to be complying with state law provisions, and so those are the provisions with regard to how long is your hearing, do you hold a hearing, what types of bonds are you issuing and for what purposes. Again, state code of Iowa driven. Bond counsel also will deal then with federal tax exempt provisions, which both regulations and tax code. So that's kind of the bond counsel role. Disclosure counsel role then is the securities side of the house. So again, when you go out and issue, you have federal law, you have state of Iowa law, and then you have securities law. So that's kind of the breakdown you can see there. those concepts then kind of filter all the way through in both preparation of documents and more specifically and importantly then the delivery of certain opinions or not, quite frankly. They one may have bond counsel, but not necessarily disclosure counsel. So we'll talk a little bit more about that later. Let's talk just again at a high level, the federal regulatory framework. So now, again, we're going to be rooted in securities law. So we're really talking for this concept, we're now into disclosure counsel. And so the federal regulatory framework on the disclosure counsel side, you can see there, it's the 33 and 34 Act. And most importantly, and you'll hear us when we talk to you all and go through due diligence, the overriding concept that we're dealing with when we prepare your primary offering documents, your POSs and OSs, is Rule 10b-5. And sometimes this gets kind of summarized, as you can see there, what we're trying to do, and the goal of due diligence is to make sure that in your offering document, when we take your bonds or securities off to market, we and you and everybody involved in the financing needs to make sure that we are not falsely or providing or misleading anybody as to material statements that are in that offering document. And then the latent aspect of this rule that is really, I think, the most important item to not lose sight of is that you also must not omit to state any material fact. So omission really is a thing in terms of, while there may be some not so great information or news or items to report with respect to your issuance, it really is incumbent to make sure you're meeting 10b-5 requirements, that indeed you're not omitting to state those material facts. So let me just give a very quick example. Litigation might be one. Suddenly you're involved in, or you as an issuer are sued for some matter. There's litigation, maybe it's costly. If there's a determination that it would be material not covered by insurance, well, just because it may not be the greatest news in the world, you, to meet the rule, cannot just simply omit to point out to investors that litigation is in existence and may have negative ramifications on the ability to repay the bonds. Some of the consequences, if we fail to make sure we've complied with 10b-5, are civil and criminal penalties, not to mention reputational harm. We'll talk a little bit, but this is probably the one area, as the SEC has expanded their role over the last number of years, there have been any number of situations where the public officials have been taken to task and faced either civil or criminal penalties. Certainly it does create reputational harm. And I would suggest that, some of the reputational harm can be ancillary from the standpoint that members of your governing body, your council, what have you, they may have or work in their professional jobs in the areas of accounting or banking or other things. And so sometimes, there are certainly other aspects when fraud allegations are brought to bear on an issuer that may eke into not just the professional action of the governing body, but personal as well. So you see the next slide. I think that is probably, if I could offer anything to present to elected officials, is that the reason we go through this process, the reason we go through due diligence, the reason it does need to be taken very seriously is under the regulatory framework with respect to the SEC, officials can, if they act very inappropriately, I would say, they can be personally liable for the actions with regard to the issuance of bonds. Moving on, some of the disclosure rules. So now you can see there Rule 15C212. So now we're dealing again, you've entered in as an issuer, you've sold the bonds as part of the bond sale. The issuer has entered into a continuing disclosure certificate. Just a little bit of detail here. Again, Rule 15C212 does not apply to issuers directly. It is a rule that applies to the underwriters. However, once the city or the issuer has issued bonds and entered into a continuing disclosure certificate or agreement, that is a contract. That's a contract now that the issuer has made with bondholders. And so it is that contractual obligation which brings in continuing disclosure, and that is the basis for which now the SEC could find violations by the issuer. So technically, again, the Rule 15C212 is a rule that applies to underwriters. It applies to underwriters in such a way that they cannot offer your bonds to the public unless the issuer is willing to sign a contract with a continuing disclosure contract. So moving on from there, again, the disclosure material, as a result of you signing on to C212 through contractual obligations, you must disclose material non-compliance with your previous continuing disclosure undertaking. So we'll talk a little bit more. This is where your policies and procedures come into play. This is where over the last couple of years, you've heard us ask an awful lot of questions about the 5-year look back period in reference to what has your ongoing compliance been over the last 5 years with your continuing disclosure requirements, your timely filing of material event notices, the updating of financial information and filing. And again, all that filing filters down and takes place on Emma. So just very quickly to walk through this from a procedural perspective, due diligence to prepare the official statement, the POS rather, the POS to sell the bonds to the marketplace, the OS to recognize the bond sale prices and so on, the continuing disclosure agreement entered into contractually with the underwriter so the underwriter can meet their regulatory requirements, the continuing disclosure agreement that provides for your ongoing material compliance and filing on Emma. So that's just kind of a very quick and dirty process from soup to nuts on the disclosure side. And again, all encompassed with this concept that you must continually comply with 10b-5 and the anti-fraud rules. So a little bit deeper dive into material events or listed events, generally referred to as the material events. You can see those there. Thankfully, in the Midwest, we don't run into a lot of these. I'll point out just a couple to familiarize yourself with. Number 11, rating changes. That's always one that sometimes catches folks in their continued compliance with regard to filings of material events. And the reason number 11 sometimes is tricky is that is a rating change that can also be positive. So you don't, most of these, as you'll see, deal with events that are negative in nature financially to put bondholders on notice that there might be some financial difficulty. However, rating changes number 11, you may have good news. You may get a rating upgrade, and somewhat counterintuitive, but that rating upgrade would be a material event for which you should be filing on EMMA to let bondholders know. We've highlighted in red material events 15 and 16. These are new since the spring of 2019. You can see there February 27th of 2019. These two events, and for the most part, again, 16 is a fairly negative financial event, but number 15 is the one that is, you know, the last couple of years really changed a lot of questions and monitoring for continuing disclosure. 15 is the incurrence of a financial obligation of the issuer or an agreement to covenant or event of default or remedy prior right or similar term if material. So this gets a lot of discussion. I would say this is very detailed. I would urge anybody, if you think you're going to be entering into a financial obligation outside of regular bond issuance or what have you, please consult with us and we can talk about it. By way of example, some of the things that we do see that can be foot faults with regard to this. So things like entering into certain types of development agreements in the TIF or urban renewal type setting. Sometimes those are financial obligations of the issuer, and sometimes they can be material. Other situations that we see if you are entering into a state revolving fund loan, again, because you're not required to work through when you enter into those types of situations, the full disclosure, you're not preparing offering documents or what have you. But those are the types of things that can sometimes just not be recognized. They are indeed financial obligations and should be set forth. So moving on with my slides here a little bit, there you can see a more detailed listing of the events. Again, as we analyze whether you have a material event under 15, it has to be debt. But that can be a situation where some things that you may not think are debt, we would take probably a position that indeed it is debt. I would also offer leases are another one, depending on the structure of the lease. Indeed, that may really be a debt obligation. And so that would be something that you'd want to analyze to make sure you could determine whether indeed it had to be listed as a material event. I won't go too much more into depth on events 15 and 16. You can see there some of the guidance that has been provided. I would just say that, again, please don't hesitate to ask us questions about some of those types of instruments that you might enter into. So I've already mentioned leases, development agreements. Those are really the types of situations we see the most. And again, this is all caveated in the fact that they should be material. You do not have to list every little agreement. So, you know, if you're going to enter into a lease for a copy machine or that type of thing, you know, that is not going to rise to the level, presumably, of an amount that is material for you as an issuer. I'll just say the one question we do often get is, well, what is material? Tell us an amount that is material up front. You know, unfortunately, that's really not possible. We have to kind of consider rather facts and circumstances. Obviously, issuer size, what impact it has on an issuer's budget by percentage, by amount, and those types of things. Those are all factors we have to consider. And, we do certainly try to, where we think it's amenable, determine that indeed certain agreements do not rise to the level of materiality. But it is something that has to be considered. And I would say this, unfortunately, it really does have to be considered on a case-by-case basis. Moving on to some interpretation from the SEC with regard to event 16. Again, here we're kind of into some negative connotation in terms of this event really is trying to provide to investors a concept that there might be some financial difficulty. So I think here, what I would point to, just to keep in the back of your mind, is this also would encompass modifications of terms. Now, it is modifications of terms with respect to agreements that, again, would show financial difficulty. But to the extent you're ever going to modify some type of financial agreement, I think we would certainly want to have some discussion about for due diligence background and file. Are you doing this because the situation or the reason for the change in terms would have in any way, shape, or form evidence that it's being done because of financial difficulty? Hopefully, this is one, again, that, as we pointed out, you are aware of it, and for the most part, we hope that we don't have to ever deal with it. So in order, again, to comply with all of these rules, obviously the SEC has, I'll say, suggested, I would consider it more of a mandate, that you have rules in place. Jennifer's going to talk more about the rules, but the reason for this training is, again, hopefully to remind you that you hopefully have rules in place. You should check those rules annually, give them some consideration, and to the extent you have questions, certainly let's talk about them. And I would say, more importantly, sometimes, especially if you have personnel turnover, new city clerk or anything of that nature, you want to be giving some consideration that you sit down and make sure that you have the right people who are set forth within those rules and policies and procedures to make sure, again, that you don't have any foot faults. And I guess lastly, I would say with regard to that, this is a discussion I always think is important to have with some groupthink. So that would include us, it would include your municipal advisors. Presumably your municipal advisors are your dissemination agents. So along with staff, and again, it's just trying to make sure that everybody's on the same page, checking things regularly, again, all with the role of trying to make sure that we're staying in compliance. Very quickly, as my time is moving on, the role of the SEC, I'll just let folks go ahead and take a look at this on their own. I think the most important part here is the SEC has been providing, as you see listed here, bulletins. They've been making statements. The SEC has taken a much more robust approach as to municipal disclosure. I would say, especially since MCDC of a number of years ago, but the bond market, so to speak, the municipal bond market is a very significant market in terms of dollar amount. And I think the one significant change over the years is that your bonds, whether you know it or not, are probably now traded a fair amount. So years and years ago, certainly the focus was on the primary disclosure, the POS, the OS. There was not, quite frankly, a lot of time or effort given with regard to continuing disclosure or secondary disclosure. MCDC of a few years ago really changed that. It changed it in a number of ways, including that the underwriters had to pay fairly significant monetary penalties. And as a result of that, it is a very heightened sensitivity. And I would say as a result of that as well, there certainly is a sense that at some point there will be another shoe to drop, and that will be focusing specifically on the issuer's compliance. And probably we will see some fines or penalties for certain issuers with regard to the lack of their compliance in the secondary disclosure market. So you can see there, please take a look again, not to scare anybody too much, but this kind of sets forth some of the themes. There were a lot of releases last year, obviously, with regard to COVID. We'll talk a little bit more. We have some questions. We'll talk a little bit more about some of the new statements. I think the one thing that, or just the topical areas, very briefly, that the SEC has been very focused on. COVID-19, obviously, there was certainly a year ago an expectation that was going to have probably a much more significant financial impact, but nonetheless, and I'm not sure that we have seen it have nearly as negative an impact as we thought. However, the SEC has been very clear that issuers need to be making sure they are updating and reporting to investors on an ongoing basis, both in primary disclosure and secondary disclosure, any kind of negative financial impact that COVID-19 may have had on your finances. Secondly, just very briefly, we'll talk about this more, cybersecurity. This has become a real problem. And I think if you haven't been issuing lately, as you're coming up on an issuance, one thing in due diligence, you're going to hear a lot more from us now are provisions with regard to cybersecurity, whether you've been hacked, whether you have insurance, those types of things. Obviously, the SEC is very keen to make sure that we're making investors aware of any kind of financial difficulty that has arisen as a result of cybersecurity. And then I think one thing we've run into more recently are some problems with receiving timely audits. We'll talk a little bit more about that in the Q&A. And so that's caused some filing in the interim of annual reports, maybe budgets, things of that nature, because unfortunately a lot of folks are not receiving their audits from auditors or the state or what have you on a timely basis to keep up and meet those continuing disclosure requirements. So with that, I'm going to turn it over to my colleague Jennifer, and she's going to talk to you a little bit about policies and procedures, walk you through some of those items, and then again we'll try to leave a little time for Q&A. So Jennifer, the floor is yours.
Thanks, David, and good morning, everyone. As David has set the table for establishing the framework and the importance of disclosure, both in the initial sense and the continuing disclosure obligations, I'm going to talk to you a little bit more detailed about the policies and procedures for ensuring compliance with those continuing disclosure undertakings. So the policy that Dorsey usually works with clients has three main components. We're talking about those initial bond offerings when you're preparing and approving the official statement at the outset, and then those continuing disclosure requirements that are ongoing. I describe that as the ongoing care and maintenance after you've taken the bond to market. And then the third component is the systematic training. So making sure you're intentional, educating your staff and your elected officials regarding the disclosure matters on a regular basis. And so then if we flip to the next slide, talking more in detail about those new bond offerings. Over the next couple slides, we've highlighted 5 steps that are useful for ensuring that accurate disclosure reaches the market. It's very process driven. And so the first item describes establishing a plan and a schedule. So one thing you might consider doing is holding a kickoff call, meet with the folks who are involved in this bond offering, set some expectations. Do you have any key people who could possibly be out of the office? Do you have backups established for that? So you want to make sure you've got people lined up to review those documents, help provide the financial information to those who are helping prepare the Appendix A with those details, and then setting forth a schedule that allows the sufficient time to get the work done, including the review and questions regarding that material. The second step would be managing that process of preparing the offering document. So as a disclosure officer, are the timing expectations being met? Questions, are those getting answered? So you want to make sure that all of those pieces are falling into place. Thirdly, you want to establish some roles. So coordinate who's reviewing, who's signing off. So identify and make sure that your group knows who's reviewing which part of the document, who's providing updates to those data points, who's keeping a big picture look to see if there are any new things that are going on within the city or the county that should be described in the draft official statement that you've received. Should there be anything else new that's added to that? So that disclosure officer is going to be your point person and gather all the feedback and then eventually provide sign off once edits that have been requested have been incorporated into the document. If we go to the next slide, continuing on with these steps, as David talked about, there are requirements to disclose failures of past non-compliance. So step 4 describes the situation where we need to make sure that there is accurate disclosure of any failures to provide your continuing disclosure. So in other words, in a previous bond offering, did the city or issuer commit to providing certain things? And then we can help do a 5-year look back to determine and assess whether those pieces of information were provided and were they provided on time. If they weren't, disclosure needs to be drafted to provide an accurate description of those shortcomings. So step 5 talks about giving your governing body time to review. So in the draft policies that we've worked with our clients, we talk about providing your governing body 7 days to review an official statement draft before they would approve it. Sometimes things come up and maybe that time frame is condensed or compressed, but make sure that you've got time built into your schedule for people to look at that. People seem to be getting busier and busier all the time, so you want them to have time to look at them, reflect, ask questions, and so that it's not a rush review and sign off as deadlines are approaching. So moving on, so we've reviewed aspects of getting the bonds to market. So now let's talk some more about ongoing responsibilities that apply while those bonds are outstanding. As David talked about, Rule 15C212 is it's just really critical. So with that rule, issuers have to file the items that they've committed to filing as described in their continuing disclosure certificate. It has to be in a searchable format and then filed appropriately on the EMA website. So at closing, the issuer commits to providing that ongoing disclosure, and it details what disclosure must be provided and when. And so that information needs to be on EMA on a timely basis. the responsibility for getting this disclosure on Emma is truly, it is on the issuer. Many issuers will work with a dissemination agent and have a contract to receive those services. Some issuers might make these on their own, but even when issuers are helped by a dissemination agent, that responsibility really still is that of the issuer. So it's incumbent on the issuers to kind of keep track and work with and really partner with those dissemination agents to make sure that that gets done.
Can I just very quickly on 2 points. So as Jennifer was walking through the process, again, for any folks on governing bodies, city councils, or those folks, again, you are part of the process. Hopefully, the professionals working with staff, by the time the document comes to you folks, before you're going to approve it by rule, it should be in really good shape, or what we would refer to as to be deemed final. However, it is incumbent in the governing body, the city council, boards of supervisors, they do have liability, right? It is not, even though you've had professionals drafting these documents and you've had staff, the governing body does still have a role to play in terms of it is not sufficient for it. It is not a sufficient argument to just say, well, we didn't read it, we relied on on our professionals. Everybody needs to be at least taking a look at the OS. Now that doesn't mean fly spec it or this or that, but you do have a role to play as a governing body. And then just quickly, as well, with regard to dissemination and getting things on Emma, I would say for issuers, well, filing on Emma has become immensely more easy. We really would urge you to try to work with a dissemination agent, whether that's your municipal advisor or what have you, because issuers have turnover. This is the type of thing that I think can be sometimes lost at the issuer level. So I would really urge everyone to consider, as you look at your procedures, have a real heart-to-heart with yourself and your staff, and consider whether it doesn't make sense to be hiring other outside professionals to be serving in that role for you. Sorry, Jennifer, to interrupt.
Oh, no, that's great. That's great. Yeah, so I think we can, yep, you've already moved there. Great. So in terms of responsibility, again, just kind of highlighting that this disclosure officer, it's an important role. And so again, as David was describing, you've got a lot of people who've put a lot of time into vetting the documents and putting a good draft in front of your governing bodies for review. That disclosure officer still wants to kind of be the point person and help coordinate and oversee those annual filings, material event notices, those 16 items that we've referenced before, and any other topics or subjects that could be covered by the issuer's disclosure policy. And so under bullet point, under that first bullet point talking about those public statements, there was some information earlier in the slide. It's about the 2020 staff legal bulletin. So again, you can reference that further later, but just kind of another point to keep in mind. And again, this disclosure officer, really having a good understanding with those continuing disclosure obligations, and again, partnering with a dissemination agent to get those materials filed on an annual basis, and making sure that they're done in a timely fashion. That individual then keeping informed, watching for changes, staying connected with the professionals who've helped with initially taking those bonds to market to help identify any new changes that they may need to incorporate in the process. So then moving on, so we talk a little bit about this tracking, disclosure obligations. Again, this is where you can have a great partnership with your dissemination agent. In the draft policies that Dorsey has put together and works with and works through with clients, there's a piece where the outstanding bond issues are identified, identifying key pieces, the date of the issuance, the final maturity date, the deadline for those filings, and then that disclosure officer can also keep track of the final official statement, that CDC agreements, and any other things that would be relevant for disclosure, and then documenting those disclosures that are made in a different part of that policy document. And so in cases where there's separate reports that are required as part of a continuing disclosure agreement above and beyond the annual audit, if one is required for your city, those are broken down and can be a nice way to keep track and make sure that you're staying on task for those. I mean, and it could even be as simple as putting Outlook reminders on your work calendar and making sure that's on multiple people so that you know when you need to start preparing information, and allow enough time for drafting and getting those coordinated with your dissemination agent. So just a nice cross check that you can do to help all of your filings stay in good standing. Moving to the next one, great. Filing those annual reports, so breaking down here further detail on the timing, and just setting out some guidelines as you prepare for your annual filings. 5, the notice of material events. Those aren't always planned for, but if you identify and can foresee something on slide 31 that maybe is underfoot or kind of coming to fruition, that's a great time to pick up the phone and give us a call, and we can help assess whether a material event filing needs to occur. And again, those have a short time frame. So you need to have that on file with Emma within 10 business days of the occurrence. And so wanting to make sure that there's enough time to vet the need to make the filing and then to get it drafted and described in an appropriate fashion. And then 6, just a few other responsibilities that disclosure officer would have. So then if we move on, Dave talked a little bit about this too. So one of the things during this pandemic that we've been seeing with clients would be the timeliness of audits. So the auditors haven't been immune to the effects of COVID-19, and for one reason or another, some are encountering slower audit completion times. And so be familiar with your continuing disclosure agreement. Quite often, there are provisions that will allow issuers to file unaudited financials as a way to kind of hit pause on the filing deadline, so to speak, so that if you can get some information, or maybe it's your AFR or something like that, then you can file those audited financials when they're available, and then at least have provided some information on the time frame that would be expected under your CDC. If something like that occurs, we can help walk through the different filings that you would need to make for that, because some will include a notice of an anticipated late filing, and so there are pieces like that to analyze and prepare. So then moving down to 32, where we'll talk a little bit about some of the training. And so as David was discussing, this session today is one way that as an issuer you can satisfy your annual training that is described in your policies and procedures. I talked to a client this week who said that he uses the slide deck from this presentation to work with his city council to make sure they're up to speed. The webinar is recorded and you can use that as well, but just making sure that training takes place in a systematic and in an intentional manner. There's turnover sometimes within workplaces. Sometimes people are out of the office, maybe even unexpectedly, and so that everybody knows what's expected and can make sure these things go smoothly without a hitch. So the training, while we have one slide dedicated to it, it is a very important piece of this, and making sure that you're staying abreast with what needs to be done and on the time frame within which it should be done. So kind of highlighting a few of the pieces here. Disclosure, that doesn't end with your closing. There's the annual reporting that is required under your continuing disclosure agreement. We've talked about those 16 different situations in which the SEC has determined those events are important enough that we can't wait for your next annual reporting. We need you to get those on file with Emma and put people on notice within 10 business days. And then just being aware of the SEC's attention and focus on municipal securities disclosure generally. If your policy for continuing disclosure was adopted before those items 15 and 16 were in effect, we're working with clients to make sure those policies and procedures get up to date. And we're happy to do that, and kind of wrapping a few things up. And so if we have some questions we wanted to consider, we can certainly take those now, and let Dave tackle some of those that are coming in.
All right, thank you, Jennifer. Just one before I jump into questions and answers. Hopefully, there's at least a general recognition. Disclosure, I would hope everybody views as groupthink, and I say that from the standpoint that, again, the overarching concept here is to be providing investors generally with facts, material facts, and as important, not omitting to provide them factual information. So when I say groupthink, what I mean by that is this is a process of disclosure, and it really is most beneficial. Nobody involved in your transactions wants to have any kind of securities law missteps. And so the groupthink concept in my mind is very important as part of the entire process to have staff involved, governing body involved to some more limited extent, municipal advisors, underwriters, and your disclosure counsel. We all want to make sure, again, we're getting it correct and that we're not missing anything. And so from due diligence on down to that POS or OS going to the marketplace, we all want to make sure we're getting it right, so to speak. Quickly, one question that we've been asked, what is kind of new in the past year? Just at a high level, clearly the SEC has made statements with providing disclosure regarding COVID-19 and any impact. So that is new, obviously, in the past year. Hopefully that will dissipate as an item that any of us will be discussing here over the next year. But that is new. Cybersecurity, I would say that is really just something we've been running into more and more in the diligence process, where some of our issuers have been hacked, run into a problem, and we've had to decipher whether we think it's material or how material, things of that nature. Again, Jennifer touched a little bit on audits, clearly because of COVID-19 and just some difficulties. We are seeing people having a little bit of problem receiving audits timely to be keeping up with their continuing disclosure requirements. So to try to deal with that, we've been trying to weave in perhaps interim filings of annual reports, potentially budgets, although that's a discussion point. Any other kind of public financial information that is already filed either with the state or elsewhere, kind of using that or as an interim gap to get to the point where you receive your audits. Another one that is cropping up, and this has been stated more by the SEC, we do have some situations we've been dealing with. I'll refer to it generally as climate change. Mainly we see it in the Midwest a little more along the lines of flooding. If you're an issuer that sits on the Missouri or the Mississippi River, or maybe the Iowa River, the Des Moines River, if you've consistently been having flooding problems, that's at least a potential discussion point with regard to a risk when you're issuing, especially if you're issuing revenue debt that might be sewer or water, where those types of events may really impact the finances of the issuer. And then another one that I would just caution everybody about, I don't know that this is necessarily new. I'd put it more in the category of sometimes not to be forgotten. And that is websites or statements by officials, city officials, county officials. You know, when you're in a period that you're going out for an offering, you should at least pay a little attention to what is being said publicly, what information or hopefully lack of information might you have on your website with regard to finances. Again, just as a reminder, for disclosure purposes, the way to speak to the market is through EMA and really not through websites. So I don't know that we have a lot of issuers that really use the website to communicate finances. If there is a situation that you do, you just have to keep in mind that the SEC views those websites as statements to the marketplace or to the public, which so you do want to be cognizant of what else you're putting out there in maybe a less formal fashion than actually filing something in a formal document on EMA. Those are kind of, I would say, the highlights. And then lastly, you know, continued discussion about Event 15, which we talked about, since that rule has not, Material Event 15, since that rule hasn't been in place all that long. I'll stop there. Those are highlights. Jennifer, my clock tells me we have 1 minute. Any other final item that I may have missed?
I think you covered it.
All right. Well, not that I will get any kudos from my colleagues, but I believe that I am timely. So with that, we're going to sign off. Thank you, everyone, for listening in. Hope this has been informative for you all, and certainly hope that over the next short period, we will actually get to see you folks in person here in very short order. So be safe, everyone. Thanks again, and take care.